Hello, everyone, and happy Tuesday. It is Tuesday, July the 15th, 2025, and this is America, Some Assembly Required. Anna is not going to be joining us today. I conspired with Shannon Bookie to have Anna take a day off today. She's very stressed. She's been overworked, and so we want to be able to give her a little self-care and hopefully she'll come back to us next week refreshed a little bit more and raring and ready to go. So we're going to try to go ahead and go forward today on the topic of and continue on with our learning about the Constitution of 1787. And again, I remind you that we are looking at this in depth because as we develop our international business assemblies, we have to know what is our job, what are we overseeing, what is their job, and where that's contained. And that's contained within the three constitutions, of which the first one is 1787. And it's my hope that as we go through and we look at these three constitutions, that we begin to see sort of some of the differences and some of the dividing lines, as well as, being able to get ideas in our heads to be ready to go ahead and start our holding our subcontractors to the business that they're supposed to be doing. We'll be much better informed and ready to do our jobs within the International Business Assembly. So it is about holding them to their contracts, and then eventually being able to oversee and understand the business of our state and ultimately our nation as we move into further stages. So we're going to continue on today with Article 3 of the 1787 Constitution. So I'm going to bring that up on the screen so you can kind of follow along here. Let's see here. Okay. So hopefully you all can see this. It's Article 3. And I'm going to go through this a little bit section by section with you so that, we can stop and I can kind of explain and discuss what it is that we're looking at. So Section 3 starts with Article 3 starts with Section 1. The judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. The judges, both of the Supreme and the inferior courts, shall hold their offices during good behavior and shall at times receive for their services a compensation which shall not be diminished during their continuance in office. So one of the things that I believe that they've kind of taken over and in a way overflowed their ability is placing upon us the idea of all of the administrative courts that are out there. And this clause, and they base it on this particular section of the constitutions. So one of the important questions is that I always ask within some of these documents is, to whom does this apply, right? Because in looking at these constitutions, we know that 1787 Constitution does not apply to the regular people, to each of us that are on the land. So who does it apply to? Well, it actually applies to all federal judges, meaning the Supreme Court justices and judges of inferior federal courts. Did you hear that? Federal courts. And of course, Congress in its authority to create and organize lower courts. So those federal courts are not really a broad spread type thing. They're the federal court is basically the district courts of the United States and some of the circuit courts of the United States. And so within each of our state, we have different district courts and we have different circuit courts. Now notice it doesn't go into municipal courts. It only applies to those courts. And so kind of to give you a little historical context on it, that the delegates at the Constitutional Convention of 1787 agreed on a co-equal judicial branch, and that was to check the legislature and the executive branches within the federal government, drawing on both the British model, which was kind of a lifetime tenure, and good behavior, well, sort of means good behavior, and emerging state constitutions that already separated powers. So what do they mean by good behavior? Well, good behavior in office. And that gave them leeway to be able to eventually put in impeachment clauses. And that's really what good behavior refers to, is to the impeachment clauses that go on within the constitutions. So basically what they're doing is they're vesting kind of in creating an independence of the judiciary. And so the judicial power of the United States shall be vested in one Supreme Court, and in such inferior courts as the Congress may from time to time ordain or establish. So as they were needed and as the system developed, they were going to be able to launch those other courts. But, one of the things that I think is important for all of us to remember is our courts were not supposed to be the machine that they are today. They were not necessarily meant to operate 5 days a week and our, I guess, judiciary 7 days a week in a way. They were really meant to be in season along with our governments. And that's why you see the Supreme Court in and out of session. They're not meant to be in session 7 and 5 days a week and 8 to 10 hours a day. So, understand that kind of from their origin, this began the separation of powers to make sure that they wanted to make sure that there were some checks and balances going on between the different branches within their federal government. Okay. And so the delegates really feared that there would be an unchecked legislature, and that legislature might usurp judicial functions or undermine the courts. So by vesting judicial power in the federal branch with the Supreme Court, they ensured kind of distinct sphere of delegated authority within that. In the Federalist number 78 papers, Alexander Hamilton argued that life tenure and protected salaries would shield judges from political reprisals, making them bulwarks of a limited constitution. So while they were in office, they didn't want them to be able to adjust their pay or to be able to put any kind of pressures on them in order to make sure that the judiciary stayed uninfluenced by pay or by performance types of applications. So, and then again, the good behavior was borrowed from the English practice, naturally, right, of good behavior, as opposed to, like a fixed term. So that meant judges could only be removed via impeachment, and they put in a really arduous political check by Congress. So it really takes a lot to remove a Supreme Court justice from their position, as well as some district courts. There has to be really compelling information or a breach of trust or treason that goes on in order to actually remove them. So essentially, the Judiciary Act of 1789 later on installed 13 district courts at a trial level, 3 circuit courts. These were original and appellate courts, mixed jurisdictions, and a Supreme Court of 6 justices and 1 chief justice. So there's 5 associates and 1 chief justice. The chief justice's original job, because you always had a naturally divided court, so the chief justice rarely ever had to actually vote, but they would be kind of the determiner of what cases actually came into the Supreme Court, what was worthy, whether it was jurisdictionally, had standing, and those types of things. They were more watching over the other 5 associates. So the compensation that they talk about in terms of compensation for their service, it really prohibited the reduction of a salary to prevent kind of strong arming, and it's been put as a crown style tactic of starving the benches into submission. So in England, they would take and cut their budgets and cut their pay until they actually would go ahead and do what the crown wanted them to do. So essentially, that was kind of why in section 1 they put that clause, is to make sure that there was no undue influence in the court's decisions based on pay or based on their term of office, not having a term, essentially, and then having a high bar for what constituted impeachment within that particular branch of the government. So the long-term impact of that, there was a case in 1803 called Marbury versus Madison, a very important case, and it's a very broad sweeping in terms of what Marbury versus Madison really did for all of us. And it asserted that the court's power to strike down unconstitutional laws was well within its jurisdiction, and it kind of cemented that independence that was the framers had within this Article 3. And then, of course, it set the impeachment precedents. So there's only ever been 2 Supreme Court justices that faced impeachment, and that was in 1804 and 1805. Interestingly enough, one of them was Samuel Chase, and they really, wanted to make sure that that became a very rare event, and that our judiciary stays consistent with that, and that the Congress can't overstep its boundaries of legislative, or the president of that corporation can't overstep its precedent and take it out on the judicial side of the governance. So that kind of explains section 1 a little bit, and maybe a little bit in depth for you, knowing that the Supreme Court is there to really have those help with those disputes of the time. So section 2 goes on to talk a little bit more about the judicial power. The judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made, or which shall be made under their authority, and to all cases affecting ambassadors, other public ministers and consuls, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, to controversies between two or more states, between a state and citizens of another state. And of course, they say this was modified by Amendment 11, between citizens of different states, between citizens of the same state claiming lands under grants of different states, and between a state or the citizens thereof and the foreign states and citizens or subjects. So I'm going to stop there for a minute and talk a little bit about that before we move on. So again, we ask, who did that apply to? Well, it applied to the federal courts, superior and the inferior courts, the district and circuit courts. And it dealt with constitutional questions. It dealt with federal statutes and treaty disputes, diplomatic and maritime matters, as well as suits involving the United States, multiple states, diverse citizenship parties, land agent claims, or foreign governments. Notice that in that, all of to whom it applied, you and I are not in there, right? And so this is really staying within that jurisdiction. And I know when we talk about maritime and everybody, admiralty and maritime, everybody goes, "Ooh, that means that's our all caps name." Well, at the time, we didn't have vessels like that. They were not existent at that time. And so realize that does not apply to us at all. And when they talk about admiralty and maritime, they were truly talking about commerce on the sea, coming from all over the world, but particularly from Europe, coming over on vessels within that contact. So, so in the historical content of the item, the Articles of Confederation were already there, but the government, the national government, only had really narrow courts of appeals in cases of capture. So if someone was captured, whether that's on land or by sea, they really only had the narrow parameters of governing that and intervening in that under the Articles of Confederation. So our Constitutional Convention delegates saw the need for a little more federal forum in this area to ensure that there was a uniform interpretation of federal law. And they wanted to resolve interstate and international disputes. So this is what they're talking about. Remember that interstate and between two states, and international disputes between jurisdictions. So we're all talking at the high level, not at our municipal levels of government. So the case list kind of reflects some interesting little insights to that. So foreign policy disputes, where ambassadors and treaties are all there. Commerce disputes, meaning maritime jurisdiction. So yes, they have overflowed that onto the land, something that we're all kind of fighting against in a way, not really fighting, but pushing back on by claiming our concurrent general jurisdiction, superior courts on our states, on our counties, and then suits involving the United States, multiple states, diverse citizenship parties. And notice diverse citizenship. So what could that apply to? Well, that could apply to one of us that have been stepped on by one of them, meaning U.S. citizen forces. And so land grant claims. So that was all governed by Congress. Anybody that's got a land grant or a land patent, originally that all came through Congress and was signed by a president along the way. And so, for example, the land patent that applies to my corner of the earth, it actually was signed by James Madison in 1806. And so that came through this particular part of our Constitution. And then it's also between a state or the citizens thereof, the state, meaning our state government, our de jure government, and then of foreign states. So under the historical context of this, we have to know that interstate friction, there was a lot of that to begin with. State versus state, or sometimes it was a citizen who versed someone in another state. And they had to find a way to go through and adjudicate all of these different types of cases within their purview of the courts. So between a state and the citizens of another state was where the 11th Amendment in 1795 modified that, and it restricted suits against a state by the non-residents. So they put some more parameters on that, because I guess, rules are always written for those that want to abuse them or overstep their boundaries. And there was probably some of that going on at the time historically. So basically, the jurisdictions that this applied to were federal questions of jurisdiction. Anything arising under encompasses and disputes over federal statutes, the Constitution, or treaties. And it's the same today, where those same questions of jurisdiction, how many of us have questioned that jurisdiction in the lower courts, and the lower courts being the municipal courts? I don't want to hear it, right? But it's right here in the 1787 Constitution. The original jurisdiction, original jurisdiction mandated for cases affecting ambassadors, other public ministers and consuls, and when a state is a party. And then, because our states have original jurisdiction. And then appellate jurisdiction, so all other cases, so federal criminal prosecutions could be reviewed by the Supreme Court, with exceptions that the Congress would make. Okay. So if we move on into kind of some specific cases that they handled, they would talk about admiralty and maritime. So federal courts inherited the old admiralty jurisdiction of English vice admiralty courts, ensuring uniform maritime law. So again, we're talking about the commerce that was actually conducted on the seas, not on the land. So diversity and interstate disputes. So citizens of the different states, this prevented local bias in state courts. So if you went to a state court, then, and you were from not in that state, you were treated just the same as if you were a citizen of that state. Controversies between two or more states. It provided for neutral forms or for boundary or water rights conflicts. All right, so boundary issues. So here in Ohio in 1835, we had a little dispute with Michigan over a boundary. And Michigan actually ended up overflowing the boundary and invading Ohio. It was called the Toledo Wars. And it was eventually settled because of a bad original survey that was done between the two states when the states were being carved out. And so they had to resurvey, and then that was heard, and it was decided by the Supreme Court that Ohio was to keep its boundary where it was, and they did a redrawing and a redistricting in terms of the territories between Ohio and Michigan. So that's where one of these particular cases would have been. And then citizens of the same state claiming lands under grants of different states. Well, what that kind of means is that, there were some colonial land claims that overlapped. And so they would have to go back. And again, surveying was not as accurate as it can be today. And so there were disputes like that, as well as if the boundaries happened to be moved in one direction or the other, or maybe there was a flood and it displaced land, then that would go back and be adjudicated then within the district and or Supreme Courts. And then any suit involving the United States. So it gave the federal judiciary the authority to enforce contracts, to be able to collect debts at the time and adjudicate obligations owed to the union. So what were they talking about? The union. They were talking about the Union of States. So it was really an important part within to define this judicial power and how and who it was going to apply to. So the last part, we're going to go through and read the next section. In all cases infecting ambassadors, other public ministers, and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction. In all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, meaning that you could appeal to that, and it covered the kind of overlay and general jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. And then this last section, trial of all crimes except in cases of impeachment shall be by jury, and such trial shall be held in the state where the said crimes shall have been committed. But when not committed within any state, the trial shall be at such a place or places as the Congress may by law have directed. Okay, so we have to remember that in this time frame, when this was written, there were 13 original colonies, and they were starting to look at the Northwest Territory, starting at north of the River Ohio, or the Ohio River as we know it today, and west of the Ohio River, which, if you're not familiar with the geography of the Ohio River, it flows down to where it meets into the Mississippi, and the Mississippi was the dividing line between the East and the West at that time. So it was the Ohio River that comes down, basically flows down from the edge of Pittsburgh on down at the Pennsylvania border. And so that whole territory down and the River Ohio till it gets to the Mississippi and then west was covered by the Northwest Territory, but they weren't yet states. So Ohio was not named as a state and adopted as a state, and it was the first American state in 1803. And so at this point in time, when this 1789 Constitution was written, those territories did not have governance as far as a court within them. And so if a crime was committed anywhere within those territories, then it was up to the district courts to decide where that criminal was going to be brought, where they were going to be tried. And that was done by by act of Congress within those. So they would determine by law where that particular trial would happen and under what jurisdiction it would happen in. So some really interesting parts of the history within that. And, we have to remember that also within this was the idea of treason, because that was still quite the charge back in the time. There was always a tension between Americans and Tories. The charge of treason was thrown around sometimes maybe a little bit too easily. And so that was also something that was covered within the judiciary. So this is going to be within Section 3. We're going to go to Section 3. So Section 3, treason against the United States shall consist only in levying war against them, or in adhering to their enemies, giving them aid and comfort. No person shall be convicted of treason unless on the testimony of 2 witnesses to the same overt act or confession in open court. The Congress shall have a power to declare the punishment of treason, but no attainder of treason shall work corruption of blood or forfeiture except during the life of a person attained. So what does all that mean, right? And we've heard this come up. We see stuff on social media right now about treason and misprision of treason. And so understand that the framers' intent, it was really a reaction to the British abuse. English high treason statutes were too broad. They would punish just on the mere speech of intent. It was not. It didn't even have to be a crime or in the planning or any of that. You could be, charged with treason for saying, oh, we ought to fight back, right? That was treason. That simple statement. And so, so the framers really wanted a strict, very overt act requirement. And they also wanted to make sure that it was included. There was a statute of Edward III, King Edward III, that inspired the defining acts of war or aid to enemies as a sole basis for treason as well. So they thought that was really a good idea because they didn't want just someone who put somebody up to something to get away with walking away scot-free, or if they were aiding them, but not actually doing the act of treason, but aiding them, housing them, hiding them, whatever it is, they didn't want that man or woman just to walk off scot-free, having more or less fomented and supported an act of treason. So they included that statute of Edward III within, in terms of making sure that anybody that was connected to the act is also held against that. Now, what I find really interesting in this is also the establishment of what they called the 2-witness rule. So how does that apply even to us today? So we use the 2-witness rule. Our witness statements, when we get ready to prove our identity, what are they? They're witnessed by 2 people. And a witness of 2 people is valid ID. So it comes sort of from this 2-witness rule. So no conviction without a testimony from 2 witnesses to the same overt act. And that kept people from pointing a finger and making a false accusation and having it held against you. So, unless you've got proof or a second witness, an actual witness, the charge can't be held in that way. So, this prevented perjury, or it even prevented the politically motivated charge, because they would be under the penalty of perjury at that point and liable for criminal charges themselves if they made a false accusation in that way without a second credible witness or actual evidence to whatever the crime would have been. So that two witness rule is really important and something that we need to keep in mind as we work with our courts as well. But it really applies to many things that we do as Americans within our jurisdiction. So, open court confession. So, any confession had to be made publicly, ensuring that there was voluntary basic witnessing or a confession made as voluntary, not coerced, not induced by the desire to be let out of jail, which is a concept long gone. Because how many times does the government basically set up and use one witness in favor, under the favor of having a reduced sentence, to rat on basically, or to accuse someone else and be trapped into the same web. So this is really an important clause within the 1787 Constitution. And the last thing that I found really strange, and I really had to look this one up, was no corruption of blood. What does that mean? Well, what that meant is if you were accused of treason and you were punished for treason, which the punishment of treason was either at the very least permanent deportation, or at its very worst, death by hanging at that time, that your family wouldn't be deported necessarily, and your family would not be killed as well in this process. Now, the English had no problem with that. They would send people into servitude, slavery, they'd kill the whole family, and they had no problem with that. And our founding fathers really felt very strongly that that was an overstep of justice for that. Now, obviously, if the family was part of the treasonous act and they were either hiding or aiding or abetting someone within that act, then there would be other punishments for them for aiding and abetting. But if they were innocent of any knowledge of that treason, then they couldn't be published. And so so basically the punishments wouldn't extend beyond a traitor's life, and would protect the families from perpetual punishment, which the English were very famous for. It went into generations of punishment. And so, this was really basically pushing back against the British attainder practices that they had. So, so there's often for the punishment of treason along the way, Congress retained the authority to legislate appropriate penalties. So often it was death, but there was also long imprisonment, as I said. But it also checked their powers in that way. and it prohibited attainders to the family. It made sure that someone couldn't just declare someone a traitor, and then it made sure that it would preserve the power, the separation of powers, again, between Congress and the judiciary. So the judiciary would have the freedom to hear the case, to review the evidence, hear the witnesses, make a decision, adjudicate it, and then they could pass that on to the Congress, who would then decide what that punishment would be for treason. So it kind of kept separating out and making sure that there was no retained power, concentrated or retained power within it. Okay. All right. So, again, this part of the Constitution, we have to ask, who did it apply to? Because our Constitution doesn't necessarily apply to us, except for this clause. This clause in this section in the Constitution, it was really about individuals who took up arms against the United States and who collaborated with enemies of the United States. So we have to remember that, again, historically at the time, there was the British who had just fought the war against us. They were still pushing. We had on the southern border of Georgia, you had the Spanish trying to push up from Florida up in and try to come into Georgia. So there was always someone stirring that pot as well. And then we also had from the Louisiana side and partially up the Ohio River, the French. And they were all at war with each other at the time. So, and they were all trying to gain power. And they could see what the United States was, what it represented in its rich resources and its vast lands. And so, this was all, this had to be in place. And there were people who sympathized with the French, who sympathized with the Spanish, who sympathized with the English. And our founders were very wise to put that in its context as well. So, the English really practiced what they called constructive treason. So in constructive treason, they could just imagine that you were plotting the king's death. And they could bring that charge against you and charge you with treason. And they could do that even by just a subtle side look at the king, or a disrespect of his authority, his sovereignty, or whatever, his kingship. That could lead to a charge of treason, constructive treason. So our founding fathers were trying to undo all of these oversteps by the English and the English government, the English Parliament, and their English judiciary. So they really adopted a really narrow and restrictive definition, and then made sure that they added that little clause of the Statute of Edward III in terms of aiding and abetting an enemy, and then tried to kind of pare down the language in that to make sure that it was very narrow within its reaction. So real important information for all of us and our judiciaries as well. And that's, again, separation between powers. So, so then we're going to go on to and look at Article 4. So Article 4 says, Section 1, full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state, and the Congress may by general laws prescribe the manner in which such acts, records, and proceedings shall be proved and the effect thereof. So what the heck does that mean, right? So this clause requires that every state is to recognize the official acts, public records, and judicial decisions of all other states. It ensures that the legal judgments, statutes, and documents carry force across state lines. So that's why when we're looking at the laws, and we can thank this first Constitution for including that within it, that when a law is decided in Washington State, then it applies to Ohio. Or if it's decided in Ohio, it applies to Virginia or Maine or Florida or all of them. So what happens in one state applies to all the other states under this Constitution. And they went on to further put that in the Bill of Rights as well and reiterate that from the Constitution. But this particular article right here says they have to do it. And so when a state adopts not just a local law, but it's something that's adjudicated and brought through based on the constitutions, then all the other states have to follow that, which is why you see that stated like Marbury versus Madison as a good example that applies to all states and the federal government. Okay. So it also applies to the state legislatures in mandating recognition, the state courts, and giving effect to out-of-state acts and records, and to Congress in settling detailed rules for authentication and effect. So historically, a similar provision existed in the Articles of Confederation in 1777. However, there was a great debate whether or not it merely made out-of-state records admissible as evidence. So it wasn't that it was the law of the land. It was like, oh, well, look, this is what that state said, so maybe we should adopt that too, or we can take that under consideration. When this Constitution rolled out, it did away with all of that speculation and said, nope, if it applies over there, it applies over here. In other words, what's good for the goose is good for the ganders as well. And so so when Congress takes in and has a legislative act, the full faith and credit is given to the legislative acts, not just to the judicial proceedings, and it empowers Congress to legislate procedures and effects. Sometimes that's good, sometimes that's bad. And balancing the respect for state sovereignty with the need for national uniformity. So, we have the ability we have to make sure that any of those powers that are not delegated are retained by our states, and we have those decisions to make within our states. But where those powers exist at a federal level, then that's where we have to be cognizant of what our role is within those things that are part of their constitution, their contract to us. And so we have to make sure that they're not just creating things. And as Anna would say, there's so very little of the actual statutes at large that actually apply to us. It's so small because of those delegated powers that were given through the Constitution, the dividing lines. We always hear good fences make good neighbors. Well, good contracts make good partners as well. And so our Constitution is that contract that says, this is what we give you to do. This is what we keep for ourselves to do. And that's what this is actually talking about. So within the context of again, the balancing of respect for state sovereignties with the need for the national uniformities, ratification debates very rarely mention it, but it reflects the broad consensus on to prevent legal chaos among the states. So that's why it's important that when we're looking up laws, we're looking up all the associated cases and how that applies within those states and those areas. Okay. So we're going to move on. Section 2 of Article 4. The citizens of each state shall be entitled to all the privileges and immunities of the citizens in several states. Well, this clause really guarantees that the states must treat citizens of other states as favorably as they do their own. They can't give in desperate treatment to someone coming from another state. So this regards the fundamental rights that we have, such as, property ownership or contracts, access to the courts, preventing unreasonable discrimination against a non-resident. And I don't mean that in the term of what they talk about, resident, but someone who's domiciled on your state. So, of course, it applies to all the state legislatures and the executive authority when they regulate or confer benefits on individuals. So we know that those individuals then should be treated. So if they move to our state, we have to treat them, even though they might be Pennsylvania moving to Ohio or a Kentuckian moving to Ohio, that they are granted all the same rights, privileges, and immunities that they would be given if they had been born and a nationality on our state. Okay. So, so a person charged in any state with treason, felony, or other crime, who shall flee from justice and be found in another state, shall, on demand of the executive authority of the state from which he fled, be delivered up to be removed to the state having jurisdiction of the crime. So this is where extradition privileges come in. Now, I can tell you that right now in the other jurisdiction, in our municipal jurisdiction, our state ofs, that to go through this extradition process, it can be quite complicated. I've actually done this process before. And you have to go, first of all, to the governor's extradition office that's run by the governor. It's signed off by the governor, but they have a particular office that works on these extradition cases. But it doesn't just stop there. They have a discretion as to whether or not to contact another state and bring someone from that other state to Ohio. And you really have to work hard to be able to get extradition from another state. There are some states that, for example, California hardly ever honors any extradition, ever. And so you have to really work hard at getting extradition done. And sometimes it takes contacting basically the people who have been wronged have to contact the other state, their governor's office, and their extradition office to try to get the two states to talk together and come up with an extradition plan. It can take months. It can take at least several weeks. And if you're successful, then you can get them extradited and transported back for trial and things on your state. You have to have a very compelling set of evidence, though, in extradition. So there's almost, it's almost as if there's so much evidence that they're convicted before they even are transported in many ways. Even though they haven't been through trial yet, the amount of evidence has to be overwhelming. Again, we go back to that two-witness rule. We don't want to just accuse someone of something without substantial evidence to be able to bring that into our courts. And so this is where that comes from. So no person held to service or labor in one state, and they're talking about indenturement, or they're talking about slavery in this clause here, because we have to remember that in that time frame, that was allowed, it was lawful, and indentured people generally were working off their transport or their move or their goods to this country. Of course, then there was also the buying and selling of slaves. So this particular clause refers to that. No person held to service or labor in one state under the laws thereof. So if you were in Georgia, escaping to another, say they tried to escape up to Ohio, where they were free, or Pennsylvania, shall in consequence of any law or regulation therein be discharged from such service or labor, but delivered up on claim of the party to whom such service or labor may be due. So at that time, if they got caught in a state that maybe was not so friendly to slavery, or believed in the indenturing of people for their debts, then if they got caught, then it was up to that state as to whether they ignored it or if they sent them back. And regularly, many of the northern states, they would take and they would send them back, or they would arrange to find a way to pay their debt and free them from their indenturement, and make them free men. That's where the term free men come from. So again, once the 13th Amendment, their 13th Amendment, our 13th Amendment also did away with it, but their 13th Amendment is what they're referring to here, specifically about not allowing slavery of this sort in the country. Of course, we know 13th Amendment basically made all of us slaves under their system, but the state at the time. So that's what that clause means right there. Eventually that would disappear, or not be part of, would be within the amendments. So then section 3. New states may be admitted by the Congress into this union, but no new state shall be formed or erected within the jurisdiction of any other state. This is an important little clause. Let me read that again. New states may be admitted by the Congress into this union, but no new state shall be formed or erected within the jurisdiction of any other state. This applies to Maryland, particularly with your District of Columbia, where they tried to make the District of Columbia a state. First of all, it's a foreign jurisdiction. It's not native to American. And secondly, this particular section right here prohibits them from allowing a state to form within the state of Maryland or within the state of Virginia, which the District of Columbia encompasses a little bit of both, each state. So this is where that's stopped, right dead in its tracks. So if somebody mentions that, you can bring up Section 3 of Article 4 of the 1787 Constitution and say, no, not allowed to do that. You cannot form a state within a state. Okay. Nor any state be formed by the junction of two or more states or parts of states. So part of California can't cede within California. Now, I know that there's a movement right now for, I believe it's part of Oregon, to split off and then be joined up to, I think it's Idaho. And that's a possibility because it's not forming within, but it could re-jurisdiction or redistrict the way those two states look. But that would be up to the people to be able to do that. Okay. Without the consent of the legislatures of the states concerned. So there has to be an agreement as well, not only by the people, but by both legislatures to let the territory pass on. Okay. And the Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States, and nothing in this Constitution shall be so construed as to prejudice any claims of the United States or any particular state. Last one, Section 4. The United States shall guarantee to every state in this union a republican form of government. Let me again, the United States, Section 4, the United States shall guarantee to every state in this union a republican form of government and shall protect each of them against invasion. There's their job right there. And on application of the legislature or of the executive, when the legislature cannot be convened, against domestic violence. They're not talking about the type of domestic violence they've extruded that to. They're talking about basically kind of insurrection within the states, within the peoples themselves. And so what do we hear all the time on the Mockingbird News? We hear our democracy, our democracy, our democracy. But they're only talking about the corporation of the United States when they spit out our democracy. Because in our Constitution, we are guaranteed the Republican form of government. This section right here is an important statement in what we are doing as the American States Assemblies. We are guaranteed by them to have Republican form of government, which is what we're setting up. That's a direct vote and a direct voice in our government, in our de jure government, and they are there to provide us protection. So, what does Anna say? That the two things of government are really the two jobs of government is to protect the people and to protect their assets. And this is where it comes from, the 1787 Constitution of Article 4, Section 4. Okay. All right. Well, I'm going to stop sharing because we've done a lot of work today. And I'm going to see if there's any questions anybody has at this point that hopefully I can answer for you. I hope I didn't bore you to death. So let's see. I'm not seeing any questions. So I hope that you found this good and informational. I hope that it taught you a little bit more about how our Constitution applies and what we need to be watching for as we're going through this particular set. Those of us eventually who will be in the Continental Congress, hopefully in my lifetime, you'll be bound sort of by this 1787 Constitution, because that's the people that it really binds, is those that actually work and form our federal government. And so we need to know these things, because we as de jure members of our state have to hold our federal members to these constitutions. And so it's going to get really interesting when we get into the 1789 and the 1790 Constitution. We're going to have something to compare it against to see how they changed the language, how they narrowed the definitions, and then what we need to do to affect our state of state and our federal government as we go through. So I hope you all have a really excellent Tuesday. And I hope Anna had the chance to get some extra rest, an extra cup of coffee, maybe a leisurely breakfast this morning, have a little family time, and have just kind of a breezy, easy day. So, so thank you all for coming. I hope you learned something and able to take that back to your assemblies. And I'll see you next Tuesday. Bye.